And it's an instrument, and the word instrument means it's a piece of paper that has some legal effect. And it being the mortgage or trust deed, it encumbers the property. And the trust deed usually doesn't have the street address, it's just a legal description. So let's look at this chart here for a moment. What we have are the two major types of loans, liens, that you're going to be asked about on the state exam: mortgages and trust deeds. And in order to identify their parts, there's a borrower, there's a lender, there's a debt, there's security for the debt, and then there's a release of the debt. In a mortgage, the borrower is called the mortgagor, and the lender is called the mortgagee. Now, some people have problems with those two words because, well, I think because the word mortgagee sounds weaker than mortgagor. And we know the lender is not weak. So there's a tendency to assign the lender, who we know is strong, the strong word mortgagor. But the OR words refer to the owner of whatever it is we're talking about. And the EE words refer to the receiver of what we're talking about. So the borrower is the one that owns the property. The borrower gives the mortgage to the lender. The lender gives the borrower money. The evidence of the debt is a note. And a note is like an IOU. It's called a promissory note. And as a promissory note, it's a promise to pay back a loan. The security in a mortgage is a mortgage contract. And later when we get into contracts, I'll define a contract as a promise that the law will enforce. So what's odd about a mortgage is that you have two promises. First, a promise to pay back the loan. The second promise is you can take the house if I don't. Can you understand? The second one is a different promise than the first one. And once you paid off your mortgage, you would receive something called a certificate of discharge. Now, in the trust deed, if the borrower in the mortgage is called the mortgagor, then the borrower in the trust deed is probably going to be called the trustor. But notice the lender in the mortgage is called the mortgagee, but the lender in the trust deed is called the beneficiary. The trustee is a third party, where the trustor, that's the borrower, conveys their legal title and power of sale to this third party. A way to think about this is buying a car and financing it through the bank. Whose car is it? We're going to talk about that later. But in order for you to get the car, what do you have to give the bank? You have to give them the pink slip to the car. And you've made a promise to pay back your car loan. And you've told them that if you don't, they can have the car back. So the pink slip is the legal title to the car, and you've given them the power of sale. Once you've paid off your car loan, what do you want? The answer is you want your pink slip back. And in real estate, that's called a deed of reconveyance. That's where they give you back the pink slip to your house. The lender is the beneficiary of this arrangement. Trustees, the people that are holding the title for the benefit of the lender, who's called the beneficiary, who are they? Well, they could be just about anyone. I sold property a long time ago where the sellers were financing it. The husband was listed as the beneficiary and the wife was listed as the trustee. Anybody can be a trustee. In reality, the trustee is a subsidiary of the bank. Bank of America has their own trustee. Right? They have their own trustees. So does Wells Fargo, Chase, and Golden One, and all of the others. So the evidence of the debt is also a note, which is an IOU, a promise to pay back the money. The security is not a contract. It's not a promise. And just like the car loan, you don't make a promise to give up your pink slip if you don't pay the loan, right? That's not good enough for them. They want the actual pink slip. And so it's not a promise to give up your legal title. You have to give it up in the first place, and they're holding your house's pink slip, as it were, as security for the loan. And if you gave up your title with a deed, then you're going to need to get it back using another deed, and that's called the deed of reconveyance. Now, before we go on, I just want you to know that out in the real world, as it were, in real estate, we don't use these terms very often. I mean, we use trust deed and deed of reconveyance, and we call things mortgages, but we don't refer as a general rule to buyers as trustors and lenders as beneficiaries, but they will on the state exam. And then the other thing to understand is, what does the word mortgage actually mean? And what is this column here talking about? Because it may seem a little weird to some of you. And the word mortgage comes from two words, the Latin word mort, M-O-R-T. And I think that was the name of some guy, right? I think his name was Mort, something like that. No, that may be wrong. I believe mort means dead, like post-mortem, or to mortify, or the morgue, or all of that. So the word mort means dead. The word gage is a French word that means to pledge. And the English had their own word, which you may be more familiar with, and that word was to pawn, like in a pawn shop. So a pledging, like in a pawn shop, you have to give up possession of the item in order to get the money. In a mortgage, the pledging of the item is debt. What that means is, what the word mortgage literally means is, you're borrowing money against something, but you don't have to give up possession of it. We'll say that again. You're borrowing money using something as the security, but you don't have to give up possession of it. Now, in that sense, a trust deed is a form of mortgage. And you're going to see why in a little bit, but in California, there are virtually no real mortgages, hardly any. A study was done down in LA, and they went through the county, and there's like 1 million or so mortgages and trust deeds that had been recorded, and they found that they had like 8 or 9 mortgages, all the rest were trust deeds. Having said that, the word mortgage is used sometimes not to talk about a specific type of loan, but the word mortgage on the state exam might simply be referring to a loan in general. So if the Department of Real Estate is asking you a question about a mortgage, the question is, are they just using the word because it's a loan, or are they talking about this chart, a mortgage versus a trust deed? It would depend on the question, right? We have samples for you. So the mortgage contract, there are two parties. The mortgagor is the borrower, the mortgagee is the lender. When you pay it in full, you get something called a certificate of discharge. But if there's a default, it is foreclosed only through the courts. This is why there aren't very many of them, right? We're going to go through that procedure, and you'll understand why. If you were a lender, you wouldn't want to do this either. The trust deed has 3 parties. The trustor is the borrower, the beneficiary is the lender. The trustee is supposed to be neutral, but when, the bank owns them, I don't know how neutral they are. And they receive what's called sometimes naked legal title and the authorization or the power to sell. And then they'll reconvey it when it's paid in full. And you get a request for full reconveyance and then a reconveyance deed. And that clears the title. So you made the last payment on your mortgage. The lender calls the trustee up, texts him, and says he paid the last payment on his mortgage. We're requesting that you give him his pink slip back. They don't use those words exactly. Then the trustee makes up a pink slip for you, right, that shows your legal title and gives it back to you, and that clears the lien. It does not convey title to new buyers. It's giving the title back to the original buyer. And if the trustee doesn't do this as fast as they can, they could be fined a whopping $300. Within 30 calendar days after the loan is paid off, a request for full reconveyance must be sent by the beneficiary to the trustee. In other words, it's illegal for them to wait longer than that. Usually it's done right away. And within 21, so you have 30 days to do the full reconveyance and 21 days to actually sign and record the reconveyance deed. If there's a default, you can, if you're the lender, remember on the state exam, a trustor is a borrower, a beneficiary is a lender. And the lender, the beneficiary, if there's a default, can either do a trustee sale or could foreclose through the courts. But all court foreclosure would apply. So why don't we have mortgages? And I understand this is a little weird because we call them mortgage companies, right? Ever heard of a mortgage company? Do you know that mortgage companies generally do not make mortgages? They only make trustees, right? I'm just saying, right? But the word mortgage, people understand what it means. Trustee, not so much. So why are there almost no mortgages in California? And the reason is that mortgages involve a contract, a mortgage contract, which a contract is a promise the law will enforce, which means to foreclose using a contract, you actually have to go to court. So how would this work? If it were a mortgage and you miss one payment, they're not going to start foreclosure. Two payments, and then they're going to. In fact, California law says you have to miss at least 3 payments before they can begin the foreclosure process. So you miss 3 payments, you've got their attention. Now, what would be the next step if you're the lender? Hire a lawyer. All right, that's the next step. File a complaint. Get a hearing from a judge. Win the hearing and get the court to order the property sold. How long could that take? How long could that take, do you think? After you wait 3 months, how long could it take to get the lawyer to file the complaint, to get the hearing and win the hearing? That could take several months, but it's not over yet. The property has been ordered to be sold, so they publish what's called a notice of sale for 3 weeks. And they post a notice on the property. They nail it to your front door. Yeah, just so you don't, miss it. So we waited 3 months before we even began the court action. It probably took a few months in order to get through the court action. Now we're waiting another month, 3 weeks or so, and for the notice of sale. And then there's the auction. And if you're the highest bidder at the auction, you get a certificate of sale. Notice that's not a deed. You don't get a deed. You get a piece of paper that says, congratulations, you were the highest bidder. But the mortgagor, that's the borrower, has 1 year to redeem. That means the borrower gets to stay on the property for another year. After all of this, for another year, the borrower gets to stay there to raise the money to pay off the loan. And after a year, a sheriff's deed would be issued. How long does this process take? A really long time. And by the way, those restrictions on lenders foreclosing were put in place during the Great Depression in the 20s and 30s. But the lenders are sneaky, they're clever, they said, well, we don't want to have to go to court and we don't want it to take that long. We have another idea. Right, and by the way, this idea wasn't really being used much until after that became the law with court foreclosure. And this is the most common way in which property is foreclosed. It's called a trustee sale. So the lender notifies the trustee. 3 months is still the rule. After 3 months, they call them up. The trustee records a notice of default. In the biz, you'll hear these referred to as NODs, right? Which notifies everybody that you're in default. The trustee waits 3 months. After 3 months, there's the notice of sale. And up until 5 days before, but anyhow, it's 3 weeks and post a notice on the property. All right. So we wait 3 months, right? We record the notice of default, wait 3 months. Then record the notice of sale, wait 3 weeks, and then we auction the property. It can be done up to 5 days before the end of the 3-month period, but the sale has to be 3 months and 20 days. Right? The trustor, that's the borrower, can reinstate. That means to pay up, right? Pay up what you owe up to 5 days before the sale. Let's say you don't pay up. Then the trustee conducts the sale. They issue the trustee's deed to the highest bidder. But the borrower gets to stay there and could redeem it or sell it during that time period. And by the way, real estate agents make money doing this. So I sold just a month or two ago, a couple months ago, during COVID, a property in Willow Glen that was already had gone past the notice of default into the notice of sale. So what happens is somebody misses payments for 3 months. They record the notice of default. They wait 3 more months. They record the notice of sale. Both of these, because they're recorded, means people can see them and find out, and then they write you letters and knock on your door and try to contact you and ask you if you want to sell the property. Then there would be an auction set. The notice of sale is the auction, right? Auction.com, most of what's there are these kinds of things. And when it goes to the auction, a lot of times they're just canceled. A lot of people that want to buy these as investment properties are discouraged because the auction never happens. It gets canceled, it gets reset, it starts over again. It happens a lot. So, but let's say it isn't canceled and there's an auction. The opening bid, right? We're not talking about it being postponed or canceled. We're just going to auction. One of two things could occur. Either it could be sold to the highest bidder, that would be a third party, or it could be sold to the bank. So essentially what happens at the auction is, I think that's the next slide. What happens at the auction is the opening bid has to match or exceed the amount of the first loan and all of the costs required to sell the property. That's the opening bid. And if nobody bids that or more, essentially the auctioneer looks at the lender and says, what do you want to do? And the lender has some choices. They could give up. They don't do that very often. They could say, let's try again later and create another auction. Or they could say, give it to us. And when the bank says, give it to us, it becomes what's called an REO, which stands for real estate owned by the bank. If somebody bids more than the first and the costs of sale, they get it. Both of them, the bank and the bidder at the auction, the private person would get a trustee's deed that would give them the title to the property. So what do? They pay the costs, fees, and expenses, property tax, other assessment liens, trustees, mortgages, and mechanics liens in order of priority. And if there's money left over, they'll give it to the defaulting borrower. There is rarely money left over. And by the way, if you're hoping to get money back when there's an auction, you're doing it wrong, because people do not pay market value at the auction. That's not the reason you go to an auction, to pay market value. You go there for getting a deal. So I had the borrower hired a real estate agent during those 4 months. Could you sell a house in 4 months in this market? Easy, right? During that 4-month period, if they'd hired a real estate agent, the agent listed it and put it on the market, they would probably do a lot better than they would at the auction. The title to the successful bidder, this is called the Doctrine of Relation Back. Reminds me, to see my chiropractor every time I see that term. But anyhow, it says the title of a successful bidder relates back to the time of the execution of the trustee or mortgage being enforced and intervening leases, liens, except some. All right. So what that means, this is a timeline I put together. So we're going to start over here. Let's say I buy a house as an investment property. And so I get a loan to buy the house. That's the first trustee. Then a little bit later, I get a second loan because I want to put in the swimming pool and I need some bucks to do that. So I get a second loan and it's recorded. And then work starts on the swimming pool, right? The pool contractor's out there digging in the backyard And then I get this thing in the mail and recorded on the property, and it's called a lis pendens. And a lis pendens is a notice of a pending lawsuit. So who's ever suing me, they're not just suing me, they want the house. They have a legal claim, they say, on this house that I bought. So at this point, I'm saying I'm not making payments to anybody till I figure out whether or not I'm going to be able to keep my house. Now we have a trial. I lose. This other person really owns the house, not me, and an abstract, which is the summary of that judgment, is recorded. A little bit later, the pool contractor is tired of me dodging him, never returning calls or text messages, and he records a mechanics lien. And then a little bit later, the holder of the first conducts a trustee sale because the first hasn't been paid for months. Now, the question is, if you buy the property as an investor, let's say, at the auction, at the trustee sale, will you be taking title to the property subject to the mechanics lien, the judgment, and the second? And the answer is no, you will not. And the reason why you won't is because the trustee's deed is said to relate back in time to when the first was given. And when the first was made, there was no second lien on the property. Work had not begun on a swimming pool. There was no notice of a lawsuit. There was no judgment against the property. There was no mechanics lien. So that lien, the trustee's deed, would relate back in time to when the first was given, cutting off all the other liens if there wasn't any money. When does a mechanics lien take effect? We're going to talk about this later tonight, but a mechanics lien date, maybe it's next week, dates back to the beginning of the work of improvement. When does a judgment take effect? And the answer is the day the notice of the lawsuit was recorded. Can you see why this is called the doctrine of relation back? Right? Can you see that? I hope so. Let's say at this point in the cycle, you call the lender up and you say, look, this is really bad, right? This is awful. Life is just terrible right now. Don't drag me through the foreclosure. I can't take the pressure of that in the auction. Why don't we just do this? I'm going to just deed you the property, right? You don't have to fight me for it. Here, take it. Here's the deed to the property. That's called a deed in lieu of foreclosure. Now, the issue with that deed is a deed, as we learned last week, is effective when it's delivered to the grantee. So this deed in lieu, if I gave it to the lender at this point in the sequence, would be effective that day, which means that it would be moving forward from that point in time, which means there would be a mechanics lien on the property, there would be a judgment on the property, and there would be a second on the property. And that's why typically the lender is going to say, we don't want that deed. We don't want that deed. We've already got a deed from you. And it's called the first. And we would rather use it than the deed in lieu of foreclosure. Under, let me try this. How about this? There we go. So a deficiency judgment. Yeah, my judgment has been deficient, but what does that mean? It's a judgment against the borrower if the property is sold for less than the amount is owed. So if I borrowed $1 million to buy the house, but now it's only worth $800,000, there's a deficiency. That's what a deficiency judgment is at. But a deficiency judgment is not possible through a trustee sale. In order to get a judgment, you need a judge. And a trustee is not a judge. So a deficiency judgment would mean going to court. It is not possible if it's a purchase money loan. This is fun. What is a purchase money loan? It says it's a loan where the seller extends credit to the buyer. Those are all purchase money. Or it is a loan for the purpose of buying 4 or less owner-occupied residential units. This is a civil code thing. Let's take a look at what that means. So let's say, what is a purchase money loan? We have a house for sale, and let's say the house is worth $500,000. And there's 2 people that are interested in buying the house, Mr. Abel and Mr. Baker. Now, Mr. Abel has $100,000 cash. He's looking to get a $400,000 loan, but he already owns a property that's worth $750,000, and he owns that one free and clear. How many of you would be willing to lend Mr. Abel $400,000 to buy that $500,000 house? How many of you would do that? If you raised your hand, the question is, what would you want as security for the loan? Most people are going to say, I want this house here, right? The $750,000 house. If Mr. Abel were to give you a mortgage or a trustee on a $750,000 house, you'd probably feel comfortable about lending him $400,000. Do you really care what he's going to do with the money? Do you care if he buys a house or not? Do you really care? If he says, look, I've been studying video poker and I have an unbeatable system, I just need some seed money and I'm going to go to Vegas and I'll end up owning the casino. Right? The bank might say, sure, why not? You know, you got a $750,000 house, sign it over. And they would actually give him the money, right? You know, he could bring in his suitcase and they would put the money in the suitcase and he would go to the area and go to, you know. So Mr. Baker is also interested in buying the house. Mr. Baker does not own any real estate right now. Mr. Baker has $100,000 for the down payment. By the way, Mr. Baker has a good job. He's had it for many years. He makes enough money that it's likely that he could afford the mortgage payments. He has a habit of paying his bills on time and has a high credit score. How many of you would lend Mr. Baker the $400,000? Some people may raise, I see sometimes comments coming up. And if the answer is yes, you would let Mr. Baker have the $400,000. The question is, what would be the security for that loan? And the answer is the property he's buying. That's a purchase money loan. A purchase money loan is a loan to buy property secured by the property being bought, as opposed to secured by some other property that you happen to have. Right? A purchase money loan is a loan to buy property secured by the property being bought. But this was about deficiency judgments. So it's a $500,000 property. You get a $400,000 loan, but let's say the market tanks and this $500,000 property is only worth $350,000. There's a $50,000 deficiency. Now, because of those laws that were passed during the 1920s and 30s, in California, the bank cannot go after Mr. Baker for the $50,000 deficiency because the bank lent him the money to buy the house and made the house the security for the loan. And the logic, now I know this is going to sound just unbelievable, but what banks were doing back then is they would sometimes lend people more money on their house than the bank actually thought it was worth, hoping that the homeowner would default so they could take a farm, a business, or something else as well. I know you find that hard to believe, right? That they would do something like that. So, and also the idea is who's more sophisticated in this arrangement, Bank of America or Mr. Baker? Probably Bank of America. So what the law essentially says is, if you're a bank and you lend somebody money to buy a property, and the security is the property being bought, if it's a house they're living in and that sort of thing, if you don't get paid and you're the bank, you can take the house, but you can't go after them for any more money. You understand? You can't go after them for any more money. The bank probably knew more about what was going on than Mr. Baker did, and if they lent him too much money, that's the bank's problem. It's not his. Does everybody understand? if the loan is a purchase money loan, a loan to buy property secured by the property being bought, there's no deficiency judgment in California. But how about Mr. Abel? Mr. Abel, remember the guy that went to Vegas with the money to play video poker? Supposing he loses, right? What a surprise. And can't pay off his loan, and then the bank goes and finds out that his house isn't really worth $750,000. It really isn't. It's only worth $350,000. And there's still a $50,000 deficiency. They can go after him. And that's because the law assumes that if you're borrowing money against property you already own, chances are good you know maybe more about it than the lender does. You can hear the gurgling of the underground stream in the foundation whenever it rains, and the creaking of the walls at night as the ground is settling, and you know all the things that are wrong with the property. You understand? So Mr. Abel, because he borrowed money against property he already owned, now he could be sued under some circumstances for the deficiency. Mr. Baker, because it was a loan to buy the property, he can't be sued for the deficiency. So let's look at, I should have put a line up here. This is a purchase money loan, right? These little arrows, I know. I have high-end graphics, but stick with me on this. I know you're thinking, I was hoping he was done with this. So we have in a purchase money loan, remember that's the Baker idea, 3 parties. We have a buyer who's a borrower, we have a lender, and we have a seller. And you see these 3, So the question is, what has to happen first? What has to happen first? And what I mean by that is, if you're the seller, well, let's start with this. Does the borrower own anything? Remember, this is Mr. Baker as an example. Remember Mr. Baker? He doesn't own anything. So at the beginning of this process, Baker doesn't own anything to give to the lender as security. So let's go this way. Then there's the seller. The seller has title. Is the seller going to convey the title before the seller's been paid or after the seller's been paid? If you were the seller, would you sign the deed before you got the money or after you got the money? Probably after you got the money. So the seller's not going to sign over the title until the seller gets paid. The borrower doesn't own anything, so the borrower has no security to give to the lender. The first thing that has to happen, the lender has to fund the loan. First thing, lender funds the loan. Now money is in escrow. Then the seller will sign the deed. Now the borrower owns something, and the mortgage or trust deed is now good and can give the security to the lender. All of this happens in a controlled environment called escrow to keep people, from running off with the money or that sort of thing. The non-purchase money loan, I have to remember to erase my drawings. The non-purchase money loan, remember that's Mr. Abel. There is no third party in that loan. The seller is not involved, right? This is a loan between a borrower and a lender. Notice there is no seller. So in a non-purchase money loan, the borrower gives the mortgage to the lender gives the money to the borrower. The seller is not actually involved. Now, you might put the money into escrow to buy something, but the lender doesn't really care because they're not lending you the money on the property you are buying. They're lending you the money on property you already own. Does everybody see the difference between those two? All right. And you're going to see the law makes distinctions between purchase money and non-purchase money. And I'll bet you're all excited. You're all excited to know that. So a deficiency judgment is not possible if the fair market value exceeds the amount of the loan. It's not determined by what they get at the auction, because if the property is appraised and it's shown that the value exceeds the loan amount, the lender had the option of taking the house. So the lender can't say, well, it's worth $1 million, but only got $950 as the highest bid, but we don't want to deal with owning the property, so we're just going to sue you for the other 50 grand. It doesn't work that way, right? If the property is worth more than the loan, the lender should take the property, but they can't sue. If they choose not to, they can't go after you. And this last line here is probably the best explanation of what we're talking about. The deficiency judgment is possible only if the property is foreclosed in court and it is not a purchase money loan. Two things have to happen. One, you got to go to court to get a judgment, right? That requires a judge. And that means that 1 year right of redemption, right? Remember that? This is why this doesn't happen very often. They get to stay there for a year. You got to go to court, and it can't be a purchase loan, right? It has to be a loan against property you already own.